Linda?
Lynn.
Lynn, okay.
Thank you.
Delvin, you want to start the claim?
Yes, I will start with reading out a short statement before we start. We are here for a hearing in the matter CFI-067-2020 before Judicial Officer Maha Mehairi and is being held by way of a teleconference. Any orders or directions made after or during the course of this hearing will be issued by the registry in Dubai on Judicial Officer Maha Mehairi's instructions. The claimant is represented by Fletcher Day, lead counsel is Mr. Timothy Killen, and the defendant is represented by Baker McKenzie, Habib al-Mullah and Company, and lead counsel is Lynn McCaffrey, DQC.
Okay, thank you. Mr. Killen, you want to proceed?
Certainly, yes, Madam. Madam, this is the first CMC in this matter, and the parties seek directions to trial. There are a number of short issues on which a determination is required by the court, but thankfully these are limited. They are, as I count them, first, a question of whether there should be expert evidence, and if so, how it should be dealt with. Second, a small question on disclosure, which is a difference as to the timing of production of unobjected to documents. Third, a question of trial date and when this trial should be heard. And then finally, potentially a question over the directions for exchange of skeleton arguments. I'm not sure if this point is still taken by the defendant, but it appears that between the draft case management orders that the claimant proposes exchange that's simultaneous of skeletons. The defendant proposes sequential exchange. Madam, on top of that, you may also have noticed that the defendant's note for this CMC spends quite some time on issues relating to the CMC documents, the case memorandum and the list of issues. These were drafted in good time by the claimant and provided to the defendant in around mid-December. The defendant, rather late in the day, then sought to make amendments to those documents that were accommodated. But then after that was done, supplied some further amendments. That was after or very close to the filing deadline for the bundle. And so there are, unfortunately, multiple drafts of those documents, although they don't differ in a huge degree. There have also been some submissions made in counsel's note on those matters, but given the parties have supplied the court with notes, and given the issues to be determined at this CMC are clearly defined, it doesn't seem to me, Madam, at least, to be a good use of time to discuss those documents in any detail, although, of course, the claimant is willing and able to, should the court wish it. So, Madam, with that aside, I will wonder, shall we perhaps deal with each of those 4 points that I set out at the start in turn? And I don't know if you would like me, Madam, to address the claimant's position on all of those first, and then to hear from Ms. McCafferty, or whether you would like us to take it in turns on each of those points. I'm in your hands.
Let's take all the issues at once, and then the defendant can submit their point of view in relation to the issues.
Certainly. Thank you very much, Madam. Starting in that case with the question of expert evidence. Madam, just to give you a bit of brief background, the claimant's case here is primarily a claim in debt and breach of contract for payment of consultancy services carried out by the claimant for the defendant. The claimant also has alternative claims for an indemnity and in unjust enrichment, so in quantum meruit. That claim is made in the alternative and only on the basis that there may be a finding on the defendant's case that there was no contractual agreement for services to be carried out. As the defendant rightly points out in its note, the question of expert evidence only arises on the claimant's alternative claim in quantum meruit. So if it has no contractual right to payment, is it nevertheless entitled to a quantum meruit in respect of the services? Now, The claimant's point is that on a quantum meruit, a party is awarded the value of any benefit provided to the defendant. And the usual approach to assessing that value is to calculate what the objective market value is. Now, in this case, the service that was provided was provision of consultancy services. Now, that is not something the claimant submits that the court would have any knowledge of. That the judge here in this case is very unlikely to have worked as a management consultant, and even if they had, they'd be very unlikely to know what the current rates are for management consultants working in this field. So the point, really put very shortly, is that the claimant says, well, if that claim is going to be determined, then what the court will need is evidence of what the market value of consultancy services are. And so in that regard, the court will require expert evidence. It will require evidence from people who are experienced in the field of management consultancy and know what the sort of charges are, what the sort of charging structures and models are. Now, the defendant suggests that that value can just be calculated by reference to the contract documents, the underlying documents, and the party's own factual evidence. But unfortunately, that isn't the way that these claims are approached or are properly approached. And Madam, I've got at tab 18 of the CMC bundle, the case report in the case of McInnes and Gross, which was a decision of Mr. Justice Coulson, as he then was, in the High Court in England, Queen's Bench Division in 2017. Madam, if possible, would you be able to turn that up at tab 18? Because I'd like to just take the court to a few short paragraphs of it.
Yes, 1 second.
Thank you.
Tab 18?
Yes, that's right. It starts, Madam, at page 165, but the relevant section starts at page 197.
197. Okay.
Thank you. Now, this was a case, Madam, where there was a dispute over whether a contract was agreed over a dinner at Zuma, not the DIFC one, but the one in Mayfair in London. And the dispute was whether there had been an agreement between an investment banker and a businessman over dinner as to the sale of a company and what, if anything, the investment banker was to be paid. And there was a primary claim in contract and then a secondary claim in quantum meruit. And Mr. Justice Coulson sets out at section 6 of the judgment the principles for assessing a quantum meruit. And at paragraph 163, which starts at the bottom of page 197, it's explained that a claim for unjust enrichment is not a claim for compensation for loss, but for recovery of benefit unjustly gained by a defendant at the expense of the claimant, which is sometimes referred to as a transfer of value. Going on then to page 198, it said the starting point for identifying and valuing any benefit to the defendant is the objective market value or market price of the services provided by the claimant. Going on then at paragraph 166, Mr. Justice Coulson here is addressing a submission very much along the lines that the defendant has made in these proceedings, that perhaps what one can do is just simply look at the agreement that was meant to have been entered into and say, well, we can use that to assess value. And to that submission, Mr. Justice Coulson says, however, such circumstances would be fairly unusual and or limited, and it will usually be the case that the court will require other objective evidence relating to market value over and above the agreement reached between the parties. So the question then is, well, what evidence is required? And that is addressed in this judgment at section 7.3 under the heading Objective Market Value. And at the bottom of page 199 is really the nub of this issue, where His Lordship there says, starting from the second sentence at the bottom of the page 199, in the absence of any objective evidence as to market value of the claimant's services, I could not possibly rely on the 13.5 million figure alone. There is nothing against which that figure can be measured or otherwise assessed by the court. That reflects Mr. Weisselberg QC's submission that in an ordinary case like this, that which was agreed can only ever be one factor in the court's assessment. And my conclusion that, at least in the ordinary case, that submission is correct. So one simply can't just look at the agreement, as the defendant says. Paragraph 183, the solution is put forward. And this is the section, madam, that I extracted in the skeleton argument. And it says there, second sentence of paragraph 183, in a case of this sort, that is normally provided by way of expert evidence. In the present case, the first defendant made clear in his defence that this is what he expected the claimant to provide. Furthermore, the claimant was aware of the need for such expert evidence because he expressly referred to his provision of such expert evidence, again after disclosure, in an answer to a request for further information from the second defendant. Again, however, no expert evidence was produced after disclosure. In my view, any alternative claim for a quantum merit in the present case could not have been advanced in any way other than by an expert's report, because arrangements of this sort are complex and the court has no experience of the relevant market, and so is quite unable from its own knowledge to fix a market value for the services provided. Finally then, madam, at paragraph 188, there is a mention there of something that the claimant has suggested by way of compromise to the defendant. It was thought inappropriate in the case before Mr. Justice Coulson, but it is said there that there was a case of Mr. Justice Jacob in Vedatech, where a quantum merit claim can be sent off for assessment by a third party, although that suggestion wasn't followed up in McInnes and Gross. So the situation, we say, is that it is clear that this is a case where expert evidence will be required on the quantum merit claim. But as I say, madam, I agree with Miss McCafferty that the quantum merit claim is only an alternative claim. Now, that then means that unfortunately the defendant's optimism as to how quantum merit can be calculated is, we say, misplaced. And it's right that expert evidence will increase the costs of proceedings, and the claimant is as keen to avoid that as the defendant is. So it seems to me, madam, that there are probably three options that might be followed here. Either the court can simply order expert evidence in the usual way as part of the timetable, and it can all be heard together. And should the judge consider that the quantum merit claim is the basis on which the claimant can recover, then that expert evidence can be considered. That obviously runs the risk that expert evidence is got by the parties and paid for, but is perhaps not used. Alternatively, the parties can agree the value of the services to the defendant. I would suggest they agreed that value as being the same as the value pleaded under the contract, which seems to be what my learned friend is getting at in her note. That would then dispense with the need for expert evidence completely, because of course there would be an agreed value for the quantum merit claim. So were it to succeed, the value wouldn't need to be determined by the court, it would simply be agreed between the parties. Or, third, the other option is that which was suggested by my client by way of compromise, which is that the quantum merit claim can be assessed separately, if necessary by way of a separate hearing. So if following the main trial, the claimant fails on its primary claims in contract and debt, and the quantum merit claim succeeds in principle, then there can be basically a quantum hearing to assess the objective market value. Now, Madam, we are in the courts and the defendant's hands as to which of those options is preferred, but I'm afraid that simply ignoring the issue and pretending that this claim or this aspect of the claim can be determined without any expert evidence is, we say, clearly unrealistic and certainly contrary to the clear guidance that was set out by Mr. Justice Coulson in McInnes and Gross. So, Madam, those conclude my submissions on the expert issue, and I suggest that perhaps if any of my three suggestions find any favour with Ms McCafferty, then perhaps I might be able to respond as to which of those is preferred. But as I say, unfortunately from the claimant's point of view, it's clear that expert evidence is required. So that then takes me on to the second point, which is disclosure. Now, this disagreement centres around whether the parties should produce documents in response to requests to produce, which are not objected to, at the same time as any ruling on disputed documents, as the defendant suggests, or before, whilst the ruling on disputed documents is ongoing, which is as the claimant suggests. Now, the claimant suggests simply that those documents, so where a request for disclosure is made, a specific request, and it's not objected to, the claimant suggests that in the usual way, and certainly in usual practice that I've seen in this court, that those documents are simply produced within 14 days. The defendant suggests rather that there should be no production at all until all of the requests to produce are determined, and then all documents should be produced at once. Now, as I say, Madam, it seems inefficient to require the parties to hold on to documents that aren't disputed and to produce them later. That simply means that there isn't as much time for each party to review the documents that aren't objected to. Rather, the party will have to wait longer and then be dumped with a larger number of documents that they will then have to go through. So, to the claimant at least, it seems as though the defendant's suggestion to produce in what's said to be 2 stages rather than 3 just simply causes delay and will drag these proceedings out. It seems to us to be inefficient, and it also isn't the approach I've seen in this court. It also, Madam, seems contrary to Rule RDC 28.20, which does suggest that where there are no objections, documents should be ordered at a time to be ordered by the court. So that does seem to be the usual way. So we would urge that the disclosure approach set out in the claimant's draft case management order is followed. That then takes me to the third issue, which is timing. The claimant suggests a trial date before summer in July of this year. That is 6 months away. That is importantly within the target date for the trial that's been proposed by the registry. And I believe there was an email sent by the registry saying that trial of this hearing ought to be heard within 6 months of the date of the CMC. And so, faithful to that suggestion, the claimant has suggested a trial timetable that meets that target. This is a relatively straightforward case, certainly by the standards of this court. It is primarily a construction of the contract, some background facts. It is probably a 3-day trial. We say there's no reason, even if expert evidence were required, that this couldn't meet the registry's target date of 6 months. The defendant suggests September as a trial date, so some 7 or 8 months, which is of course outside the target date. Unfortunately, owing to the legal representatives, claimant's legal representatives, primarily my availability, I have no availability in September, so really that will mean a trial date in October if my dates are to be taken account of. We say that the registry's target date should be met. There's no reason why it can't be in this case. And so we suggest that a target date of July is appropriate. If it has to pop over into August, then perhaps that might be the case. That then leaves my final point, Madam, which is direction on exchange of skeletons, it's simply just noting the defendant's case management order suggests sequential exchange, so the claimant's skeleton to be filed first, followed by the defendant's. The claimant suggests instead that it should be simultaneous exchange. That again has been the usual practice of this court, certainly that I've seen. There doesn't appear to be any need for sequential exchange here. The parties' cases are fully set out in the pleadings, and there will of course be short oral openings as well, at which anything additional can be addressed. And so really there isn't any benefit, we say, to sequential exchange, and it should be simultaneous. So, Madam, on that, very briefly, what we say is there should be expert evidence because it's necessary. So it should be ordered by the court. We're open to the method in which expert evidence is dealt with. On disclosure, we say that the usual order should be made and unobjected to documents be provided earlier to give the parties more time with them. On timing, we say that a trial date within the registry's target date of 6 months is eminently possible, and there ought to be a trial set down in July. And for pre-trial directions, we say that there should be simultaneous exchange of skeletons, not consequential. So, Madam, unless I may assist further, I think those cover all of the issues between us for this CMC.
Thank you. I have no further questions. Ms. Lynn, you want to provide your submissions?
Yes, thank you very much, Madam. I'll go through my submissions in the same order in which Mr. Killen has made his submissions, and we'll deal with each in turn. So I shall start first of all with the issue of expert evidence, and this is something which has only really come up very close to the CMC. Initially it was unclear what kind of expert evidence the claimant was suggesting might be needed. It's now been made more clear that what they're seeking is expert evidence in relation only to their alternative case in this matter. The authority that the claimant relies upon, the case of McInnes and Gross, was a case very much decided on its own quite unusual facts, and in that case Mr. Justice Coulson, as he was at the time, in fact dismissed the primary claim and also the alternative claim in quantum meruit. So the comments that Mr. Killen took you to, Madam, are all obiter comments, because in that case there was no finding for the claimant there. In the present case, the claimant has formulated and quantified its alternative case in the very same sums as the invoices it's claiming under its primary case. And it may be helpful for us to look at the particulars of claim to see how this alternative claim has been formulated. Madam, if I could ask you please to turn to the CMC bundle, and the particulars of claim appear in section 5. And the alternative claim is set out towards the bottom of that document, and on the system it appears on, it starts on page 53 of the system, and this is where the quantum meruit claim is pleaded. And at paragraph 23, the basis of that claim is set out, and what we see in paragraph 24.2, which is on page 54 of the bundle, that the quantification of the quantum meruit claim is in precisely the same sum as the invoices it seeks under its primary claim, which is paragraph 24.1. And the way it's put is, the claimant says it claims the sums as set out in the invoices as a reasonable sum in respect of the phase 2 services. So the claimant's not putting forward any positive case as to the market value of the services it alleges it provided. It's merely saying that if it's not entitled to these invoices under the terms of the contract, then it's still entitled to those sums by way of quantum meruit. So that's an issue which raises a number of legal points. It also raises a number of factual points, and it's all very much tied in with the same legal points and factual points that arise for determination in respect of the primary claim. which is whether those fees were ever agreed, whether authorisation to carry out any of those services was ever given by the defendant to the claimant, and so on. So this is not a case where the claimant on its own pleadings is seeking for the market value of its services provided to the defendant to be quantified, to be assessed by the court. This is instead a case where the claimant has, as its alternative claim, essentially the same claim as its primary claim, the same sum, and relying upon the very same invoices. So it seems to the defendant that this is a very different kind of case to the case such as McInnes and Gross that's relied upon, where in that case the claimant was seeking to have a whole account of the services it had provided over a considerable period of time, and for there to be a market value placed on each and every one of those services. This is quite a different case from that. Further, the defendant says that it's not proportionate in this case to order that there be expert evidence, and it's important to note that the McInnes case was a claim for over 13 million euros, and here the claim, if one looked at it in terms of euros, would be roughly 3 million euros. So it's a much lower claim, and one has to have consideration to the proportionality of ordering expert evidence in this case. The claimant in submissions today has set out a number of different options. It was said that there were 3 different options for how to deal with this, and I'll look at the options in turn, but there is a 4th option, which is the one the defendant favours. And I'll start with the 4th option that the defendant favours, and that's simply that, as set out in the defendant's skeleton, that this is a matter which, if at the final trial the court dismisses the primary claim but allows the alternative quantum merit claim, that the quantum of that claim is then assessed on the basis of the factual evidence, the witness evidence that's provided. And as I've just explained, that's going to be a very different kind of exercise from McInnes and Gross, because there the court will be having to decide simply whether the invoices that have been issued by the claimant in the sums that they've been issued should be paid by the defendant on a quantum merit basis. Now, I'll come to look at the 3 options that the claimant set out. The first option was the suggested expert evidence could be provided in the usual way, which is that there would be an order made today that expert evidence be provided in advance of the trial. And the difficulty with that order, Madam, is of course that this being an alternative claim, there is a very real risk that that expert evidence would be redundant, and the cost of that would therefore be wasted. The second option that Mr. Killen set out was that the defendant simply agreed that the value of the services that it was provided with is the same as the value of the invoices. And Madam, you won't be surprised to hear that the defendant does not agree that. And the defendant's case very much is that if the primary claim fails, the alternative claim also should fail, because there's no basis on which to make quantum merit, but in any event, those services were not authorised by the defendant. So even if the primary claim fails, there's still a question of whether those services were actually instructed by the defendant. And the third option that the claimant set out was the one set out in their proposed directions, which is that quantum merit be assessed separately at a separate hearing. I just want to say a few things on that, Madam, in case that's an option which you decide to go with. The claimant's suggestion is, in my submission, likely to add considerably to costs, because the claimant's suggesting that there be a whole other trial with a whole other set of directions after the final liability trial in this matter. And what they're suggesting is that there be further factual witness statements as well as expert reports. And that would be very costly, but in addition, it would put an onerous and unacceptable burden on the witnesses in this matter, because it would require them to provide 2 witness statements and potentially require them to attend and to be cross-examined and to give their time to attend trial on 2 occasions. And that would be a waste of cost, and it would also be unfair on the witnesses. So if, Madam, you were to decide to go with the claimant's suggestion of having expert evidence after conclusion of the final trial, in the event the primary case is dismissed but the alternative case is accepted, then there should simply be expert evidence provided within a short time period after that trial, followed by a short quantum trial of the expert evidence, but the factual evidence should be provided in the first trial, and any questions which are to be asked of witnesses in relation to the quantum merit case should be asked in the first trial. So there's no duplication of effort and no duplication of time for the witnesses. But as will be clear from my submissions, both in the skeleton and today, Madam, that's not an option which the defendant supports. The defendant says there's no need for expert evidence at all in this case, and none should be ordered. So, having looked at expert evidence and having said that we submit that none is required, but having gone through the options that are being presented by the claimant, I'm going to turn now to look at disclosure. And the disclosure point is really a small point between the parties. The defendant's concern is that the claimant's suggestion requires disclosure to be essentially made on 3 different occasions, with all the costs that go with that, and it ends up being a 3-stage process rather than, as the defendant suggests, a 2-stage process. Under the defendant's suggestion, there's initial disclosure on the initial date, and then there'll be a second round of disclosure in response to the requests to produce further documents, and that will include both the documents to which no objection was raised and also the documents which the judge orders should be produced. And the rationale for that suggestion is simply that the cost of disclosure will be brought lower. The objection that seems to be made by Mr. Killen is that that wouldn't give as much time to look at the documents which are produced following a request where no objection has been raised. And really, we're only talking about a period of a couple of weeks after the dates that the claimant is seeking. But in any event, the dates that the defendant proposes in its trial timetable would allow ample time for consideration of the documents. The defendant's timetable has a period of 6 weeks after the final round of disclosure before witness statements are due, and 6 weeks would be more than enough time for the parties to consider the documents and to provide witness evidence. And it was suggested by Mr. Killen this morning that the defendant's suggestion is contrary to Rule 28.20 of the DIFC rules, but that rule doesn't give any suggestion that those documents to which no objections are raised have to be provided straight away. That simply sets out the steps that the parties have to go through before disclosure is made. So there's no support for the claimant's submissions in that rule. I'm going to turn thirdly now to the submissions that Mr. Killen made regarding the trial date. And of course, the defendant acknowledges that the registry has suggested that the trial date should be within 6 months of this CMC, and that's something which the defendant has very much given thought to. The claimant's initial suggestion for the trial date, as Madam you will have seen from my skeleton, was the 25th of July, which came immediately after important public holidays in Saudi Arabia, where my client is based and where all its witnesses are based. And so that date would have caused, obviously would have caused great difficulties for the witnesses in this case, and also for those from whom we in the defendant's legal team take our instructions. And this was why the defendant suggested as an alternative to that a date on the 5th of September, which was only 5 weeks after the date proposed by the claimant. And the reason why the 5th of September was suggested was simply in order to avoid the August period, as it was acknowledged that that may cause difficulties for others who had planned annual leave during that month. But there's certainly no reason why the trial couldn't happen towards the end of August if there's no difficulty with availability dates. Now, one thing I should mention is that it was never suggested by the claimant in response to this proposal by the defendant that there were any availability difficulties in September. It was only with the claimant's skeleton a couple of days ago that it became apparent that it said there's no availability for the claimant in September. That's the first that the defendant knew of that. It was slightly vague in the skeleton, but I understand from what Mr. Killen's saying today that he has no availability at all in September. And of course that's unfortunate, but as I said, there's no reason why this couldn't come forward into August. The dates that the claimant is now proposing are early in July. They are much less than 6 months away. They're just about 5.5 months away. And in order to meet those dates, the timetable that the claimant is proposing is somewhat truncated. And so, for example, it gives only 3 weeks after disclosure of documents before factual witness statements are due. It then only gives 2 weeks for reply witness statements to be provided, and unfortunately those 2 weeks fall directly in the middle of Eid holidays, which take up 3 days of public holidays. And so the dates that the claimant is suggesting to enable them to fit a trial in early July, in our submission, simply don't work, and they would cause considerable prejudice to the defendant in attempting to take witness evidence, and it simply isn't going to work if there's going to be witness evidence required over the Eid holidays. And so the proposal that the defendant has made takes those Eid holidays into account. The timetable avoids Eid holidays by having the witness statements falling in between the May and the July Eid holidays. So the witness statements are due in June, which gives everybody sufficient time to deal with them. And the defendant is happy for the trial to take place later in August, so that the registries wish to have this dealt with as close as possible to 6 months after the CMC can be managed, but early July is simply too early in defendant's submission. I'm going to turn now, if I may, just briefly to the fourth point which Mr. Killen made, which is in regard of skeleton arguments. And Mr. Killen has suggested that the usual practice is for skeleton arguments of the parties to be served at the same time. Of course, I would defer to the court's experience in this matter, but that's not my experience of this court. And I would look, Madam, at the DIFC rules on this point, and Rule 35.62 and 35.62A, where they refer to skeleton arguments for trial. In both cases, it's envisaged that the sequential exchange of skeleton arguments is the usual practice of this court. Madam, you may have your own views about that, and of course I defer to that, but given that this is in the rules as the default position, as the standard position, then there seems to be no reason to depart from that. And regardless of the fact that there are detailed pleadings in this matter, and there will be, by the time of trial, be factual witness statements. Of course, a claimant's claim can evolve during the course of preparation for trial. issues can be narrowed once witness statements are provided. Certain issues can take greater priority, and there are things to be said about what the witness evidence on the other side reveals. And I would submit that it's fair for the claimant to put out their position first in their skeleton argument, and for the defendant then to have a short period in which to consider any changes in the way in which the claim is being put by the claimant, so that they can be dealt with in the defendant's skeleton argument. And that simply will also save time, because it means that the defendant isn't faced with having to make more detailed oral submissions on the first day of trial to deal with any changes in the way in which the claimant's claim has been put in their skeleton argument. Now, I've dealt now with the 4 matters which Mr. Killen set out by way of submissions today. I do just want to deal briefly, if I may, with a further point which he referred to in passing, which is the CMC documents. And I would like to correct a few things that Mr. Killen said about that process. He was rather dismissive about these documents, the case memorandum and the list of issues, but they do fulfil an important purpose, which is to have a record for the court to be able to refer to, and they're referred to not just for the purpose of this CMC, but they're referred to subsequently and can be referred to by the court in advance of the trial. So they are important documents, and it is important that they are an accurate record of the parties' pleadings, an accurate summary of the parties' cases. And what Mr. Killen has said is that he says that it was in mid-December that the claimant served its suggestions. It was in fact on the 19th of December, so very close to the period when people are going on Christmas holidays. My clients responded to those suggestions 2 full weeks before this CMC. It was suggested by Mr. Killen that we only responded late in the day. I would suggest that responding 2 weeks before the CMC date is ample time. There was then, as there often is in these cases, a bit of toing and froing about the wording of these documents. There was a telephone call between the parties to discuss it. The claimant provided its further suggestions on these documents, to which the defendant responded within a few days, and those few days having followed over the weekend. And contrary to what Mr. Killen says today, the defendant responded with its final set of comments before the deadline for serving those documents and before the deadline for serving the CMC bundle. It was 24 hours before those deadlines. And the suggestion that the claimant didn't have sufficient time to look at them before that deadline, in my submission, seems to be rather unrealistic. But in any event, there would have been sufficient time from Tuesday last week until today, over a week, for the claimant to have given its consent to the small number of changes that my client sought. I don't propose to go through all the changes because, as Mr. Killen said, I've set them out in some detail in my skeleton argument. But what the defendant is seeking is simply for the case memorandum and the list of issues to accurately reflect its pleaded case. And the claimant hasn't come up with any justification for not accepting our small number of changes. And the reasons that the claimant has given for objecting to them don't amount to a justification. The defendant has set out in its skeleton argument exactly where in its pleadings these points are made, and I would submit that it would be helpful if the court were to order that the defendant's changes be implemented into these documents and that be placed on the court record for future reference. And it is rather unfortunate that the claimant has taken such an unreasonable approach to these documents and is continuing to do so, and that's rather regrettable. Now, there's just one final thing, Madam, I would also like to put on record, and it's something that's important to those I'm representing today, and that's a query that's made in the claimant's skeleton argument about the status of the defendant's legal representatives. And there's a complaint made that one of the fee earners working on this case is not registered with the DIFC. And I just want to make sure that it's clear that there are 3 fee earners who are working on this case on behalf of the defendant, and the 2 most senior of those are indeed registered with the DIFC. In fact, they are based in Dubai and they have many, many years of experience in Dubai. And both of them are the solicitors who have overall conduct of this matter. And the solicitor that was mentioned in the claimant's skeleton argument, Miss Lisa Easterbrook, is the associate who is assisting the 2 more senior fee earners, and she is working under their supervision at all times. So it seemed something of a cheap shot for the claimant's skeleton argument to cast aspersions on her involvement, and that's something that I wanted to correct. Madam, if Madam, you have any questions about any of the submissions I've made, then I'll be very happy to answer them. But those are the points I wanted to raise today.
Thank you. No questions. Mr. Kellen, you want to reply briefly?
Yes, thank you, Madam. I'll be very brief. If I could start just perhaps in reverse order on that point on the defendant's legal representatives. We say nothing further on that. That's really just a matter for the registry. All we note is that the registry did expressly ask when a document was served that it be served by somebody who was registered, and I believe there were more documents served, but as we say, that's not really for us to get involved in. On the CMC documents, I would just like to make clear, because it was said that my client was being unreasonable, I think, in this, that it does sit rather ill in the defendant's mouth to complain of being unreasonable and uncooperative when documents were provided on the 19th of December that weren't responded to until the 12th of January. Those changes were accommodated, but then the day before the bundle was due to be filed, which is the deadline for the filing of the CMC documents, there were further changes put in. Some of those changes, rather unusually, as I say, reversed the earlier changes that were sent on the 12th of January. So it is a bit difficult when the claimant prepares documents a month in advance, well over a month in advance of the hearing, for the claimant to be told it's been uncooperative because it hasn't rushed around in the final 24 hours before the deadline to accommodate the defendant. The defendant, there is no need, we say, for the defendant's changes to be approved. The defendant's document is on record because it is in the CMC bundle, it's on the registry record. Madam, if the court is considering going through the changes to the CMC documents that were made with a view to approving them, then I would ask to address each of those changes. But what we say is there isn't really any need for that. If Ms McCafferty's concern is that there's no record of it, well, it is on record because it's in the CMC bundle. I have no further submissions to make on skeleton arguments. I note simply what I said before, that there are full pleadings and that there's no real need for there to be early knowledge of the claimant's skeleton. It could be done in the usual way and exchanged simultaneously. On the trial date, I note the defendants say that they could accommodate August. If this matter were to be pushed out to late July, early August, then the claimant would be content with that. Really, the claimant is keen for this case to be heard as efficiently and as quickly as possible, whilst also having a realistic timetable. It's important, we say, that the DIFC court registry's targets are met, and if late July, early August will accommodate that, then we're very happy with that. On disclosure, my learned friend sought to justify holding on to documents for as long as possible by the fact that there was a 6-week additional time period after disclosure. And so that is the time it was said in which documents could be reviewed. Well, what we say to that really is there's no need for that additional time to be built in, and if we're to deal with this efficiently, then documents that aren't objected to should be supplied early so that the parties have longer with them. Documents are going to be important in this case, and there isn't really any need for the defendant to hold on to documents for longer than possible. That, Madam, then just takes me very briefly to expert evidence. On the judgment that I referred to, McInnes and Gross, I disagree strongly with the suggestion that authority and the parts that I took to it were anyway confined to their facts. Mr. Justice Coulson was very clearly discussing the general case, and on a number of occasions in the passages I took the court to, said in the general case, in the usual case. And it certainly, we say, stands as good guidance in how such cases should be dealt with. On the pleading point, where it was said that there is a formulated sum, on that, Madam, we say there's no positive case as to market value that's put because we need expert evidence in order to put it. So at present, what we say is market value, in the absence of that expert evidence, is the price that was charged. But it is clear that what we are claiming is a quantum merit in the usual way, which is a reasonable fee. That is what's pleaded at paragraph 23.4. And to put beyond doubt that the normal approach on quantum merit is being taken here, one can see at the prayer at number 4, which is at page 55 of the bundle, that the claimant claims compensation or damages to be determined. So it isn't, we say, right to simply say that because a figure has been put on it of the invoice figure, that we therefore don't have any need for market value. As McInnes and Grace made very clear, that's exactly what is to be expected. On proportionality, my learned friend said that it was justified in McInnes and Grace because that was a claim at a higher value. It was for about 13 million euros, I think. It was a euro denomination rather than pounds in that case. This is not a case of that order, but it is one for 14 million Saudi riyals, about $3.7 million. So we say that is certainly a claim that is large enough to justify what would be a proportionately modest expense of expert evidence. Finally then, on the options that are available, I understand that my learned friend objects to expert evidence entirely, but I understood that it was said that the second option, so expert evidence to be determined following trial should it be necessary, was the preferred option if expert evidence is ordered. I understood my learned friend to take a point that there shouldn't be additional factual evidence and that the quantum assessment hearing should be just expert evidence. On that, if that were to be the case, we would be content for all factual evidence to be dealt with in the trial, so that the quantum assessment would just be based on submissions, the factual witness statements that have been put in already, and any additional expert evidence. So we would be content with that if that option is that which is preferred by the defendant of the options that involve expert evidence. So, Madam, I think that concludes everything. But before I sign off, if I could just take you to page 55, just to demonstrate something I was saying earlier, which is at tab 5 of the bundle, and that is the pleading at the prayer. Just to emphasise that there is very clearly a claim here for compensation or damages to be determined. That is set out at the prayer at paragraph 4.
Mr. Cullen?
Yes, Madam, sorry, I was just, are you on page 55?
Yes.
Wonderful. So it's just paragraph 4 there, where the claimant claims compensation or damages to be determined, just to make clear that it isn't a claim for 14 million reals or nothing, there is that there. But of course, the alternative claim can't be quantified until the expert evidence is in. So, Madam, those conclude my responses. We would be happy for a trial if it were pushed back to late July, early August. And in terms of expert evidence, we say it is necessary. I understood that the defendant's preferred approach to it was to have a separate quantum hearing of expert evidence alone and submissions, possibly cross-examination of experts. We would be content for that as well. Madam, unless I can assist further, I think that is everything in response.
I have no further questions. Thank you both for your submissions. The court will take the parties' submissions and will revert with directions through email.
Thank you very much.
Thank you for your time. Thank you. Goodbye.
Thank you.
Thank you very much. Thank you.